Friends, Namaskaram. In today's class, I will discuss one of the most important case of check bounce, wherein the allegation of prosecution is that 35 lakh rupees is given to the accused. The amount is embezzled, and finally check is given. It is also bounced, and finally the accused got acquitted from the High Court. So basically, we have to understand the defense theory. We have to understand the strategy, so that if you are going to contest a case, we could easily set up our defense and could fight our case as per the protocol. Case which I will discuss is pronounced by Honorable Chhattisgarh High Court. Judgment date is 10th of April 2026. In that case, trial court convicted the accused. Finally, appellant court acquitted the accused and revision was filed by complainant, but it was dismissed by Honorable High Court. At this junction, we have to understand three important points. In a check bounce case, the burden is on the prosecution. The accused is not required to prove the defense beyond reasonable doubt. The point is probable defense. In a revision jurisdiction, the finding of acquittal cannot be converted into conviction. Regarding this, section 442 of BNSS is quite important. Now we are coming on the facts of the case. In that case, the allegation of complainant was that accused was known to him. He executed an agreement with him regarding purchase of land, in consequence of which rupees 35 lakhs had been given towards advance. Finally, there is no sale deed. When the money was demanded back, check is issued. Finally, it is dishonored and case was filed. So whenever we are having a case against us, first of all, we have to ascertain the scenario submitted by a concerned complainant. If the case is compromised or there is material concealment of fact, then we could have the benefit. So in that case, the accused submitted that there is nothing on the record to show transaction of rupees 35 lakh. There is no documentary evidence, there is no ocular evidence regarding the same. Apart from that, the agreement is not in writing. And as per mandate of section 17 of Registration Act, if the property is above rupees 100, the compulsory registration is must. And apart from that, the ITR showing the profit of rupees 3,50,000. And apart from that, no such amount was available in the bank of concerned complainant, by the virtue of which reliance could be placed on his words. So basically, if the facts are missing and material facts are omitted, means not placed on the record, there is lack of corroboration. And apart from that, there are a lot of inconsistency in the statement of the concerned complainant, a doubt created. And finally, the case will fail. In addition to this, the accused set up this trend. He submitted that the check has been taken forcefully. He reported the matter to the concerned police plus bank, and everything is supported by document. The said documents are not rebutted by the complainant. So basically, if defense is having the probabilizing effect, the presumption of section 139 and 118 of NI Act got rebutted. Regarding this, two judgments are important. Number one, 2007, volume 5 SCC, page 264. Another one is 2006, volume 6 SCC, page 39. So in simple words, we could say that the burden is on the complainant, means on Mr. A, to prove the case. If Mr. A submits the prime element, then burden shifts on Mr. B. to prove the contrary. If the evidences are submitted to rebut the presumption, then burden reshifted on the complainant to prove the case. If the complainant failed to do so, in that scenario, the accused could have the benefit. For example, if there is no liability on the part of accused, the documents showing liability are withheld or concealed by the concerned complainant. In that scenario, a doubt is created, and I think that it is going to be justified by the government, and it is having the probabilizing effect. In that scenario, the chance to get success for the accused will be on the dominant side. So, if you are going to fight the case, just work out on four important principles. Number one, legal enforceable debt is must. Apart from that, we have to observe or see whether documents are concealed or placed on record. If it is concealed, then we could have the benefit. The prosecution has to prove the case beyond reasonable doubt. We are supposed to sustain our defense on the point of probable defense so that we could be succeeded. So I think that I have specified you things in the easier way. See you in the next lecture.